That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. We have held that all provisions of the Constitution can be applied to Jammu and Kashmir through the exercise of power under Article 370(1)(d). The power under Article 370(1)(d) can be used to apply one provision, more than one provision, an entire part of the Constitution, or all the provisions of the Constitution, that is the entire Constitution. The provision does not make a distinction between one or all provisions of the Constitution. Non-application of mine cannot be claimed merely because CO 272 applies all provisions of the Constitution to Jammu and Kashmir in one go. The next issue is the challenge to CO 272 on the ground that the President could not have secured the concurrence of the Union Government under the second proviso to Article 370(1)(d). We hold that the President seeking the concurrence of the Union Government instead of the government of the state to issue CO 272 is not invalid because, first, the effect of applying all the provisions of the Constitution to the state of Jammu and Kashmir through the exercise of power under Article 370(1)(d) is the same as an exercise of power under Article 370, Clause 3, notifying that Article 370 shall cease to exist. That is, all provisions of the Constitution of India will apply to the state of Jammu and Kashmir, except for the fact that the former can be reversed while the latter, namely under Clause 3, cannot. Second, consultation and collaboration between both the units will only be necessary where the application of the provisions of the Indian Constitution to the state would require amendments to the state constitution, because the purpose of the requirements of consultation and collaboration is for the smooth functioning of governance in the state and to ensure that the provisions of the Constitution of Jammu and Kashmir are not inconsistent with the provisions of the Constitution of India. Third, since the effect of applying all the provisions of the Constitution of Jammu and Kashmir, to Jammu and Kashmir through the exercise of the power under Article 371(d) is the same as issuing a notification under Article 370, Clause 3, which the President has the power to unilaterally issue, the principle of consultation and collaboration are not required to be followed. Fourth, the exercise of power is mala fide only if power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 370(1)(d) because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370, Clause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Quixote Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. 1. A change may be either in terms of or in its effect. 2. A change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And 3. If the effect of an amendment is to change a provision, such effect must be significant or appreciable, and 4, the substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370, Clause 1 or under Article 370, Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370, Clause 3 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Constituent Assembly. Both these changes are not insignificant because they modify the essential character of the proviso by substituting a particular type or kind of body with another type or kind entirely. Fourth, while the interpretation clause, namely Article 367, can be used to define or give meaning to particular terms, it cannot be deployed to amend a provision by bypassing the specific procedure laid down for its amendment. This would defeat the purpose of having a procedure for making an amendment to the Constitution of India. Fifth, the consequence of permitting amendments through the circuitous manner would be disastrous. Many provisions of the Constitution would be susceptible to amendments which evade the procedure stipulated by Article 368 or other provisions. Sixth, the previous constitutional orders which modified Article 370 through Article 367 were clarificatory and consequential. They did not have the effect of amending Article 370. We have therefore held as ultra vires the amendments which were made to Article 370, Clause 3 by taking recourse to Article 367. G, the status of the Constitution of Jammu and Kashmir. The gaps left by the non-application of some parts of the Constitution of India were filled by the Constitution of the state. After the abrogation of Article 370, as it stood before the issuance of CO 272 and CO 273, and the application of the entirety of the Constitution of India to the state, the Constitution of the state does not fulfill any purpose or serve any function. Hence, the implicit but necessary consequence of the application of the Constitution of India in its entirety to the state of Jammu and Kashmir is that the Constitution of the state is inoperative. On the validity of Parliament's exercise of power under the first proviso to Article 3, this is what we have said. A 5-judge bench of this court in Babulal Parate held that the views expressed by the legislature of the state under the proviso to Article 3 are not binding on Parliament. If the views of the state legislature were binding on Parliament, which is not the case, there would be scope for debate on whether Parliament, in exercise of its powers under Article 356 1b, could have substituted its views for the views of the Legislative Assembly of the state. However, the views of the legislature of the state are not binding on Parliament in terms of the first proviso to Article 3. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. Thus, Parliament's exercise of power under the first proviso to Article 3 is valid and not mala fide. The next issue is on the validity of the suspension of the second proviso to Article 3 as applicable to Jammu and Kashmir. When the reorganization bill was introduced, that is on 5 August 2019, the second proviso to Article 3 as it applied to the state of Jammu and Kashmir ceased to exist because of CO 272. Thus, the issue of whether the second proviso to Article 3 could have been suspended in exercise of the power under Article 356 1c does not survive. The next issue is the validity of the Jammu and Kashmir Reorganization Act 2019. The Solicitor General, appearing for the Union of India, submitted that statehood will be restored to Jammu and Kashmir and that its status as a union territory is temporary. The Solicitor General submitted that the status of the Union Territory of Ladakh will not be affected by the restoration of statehood to Jammu and Kashmir. In view of the submission made by the Solicitor General that statehood would be restored of Jammu and Kashmir, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. The status of Ladakh as a union territory is upheld because Article 3A, read with Explanation 1, permits forming a union territory by separation of a territory from any state. This court is alive to the security concerns in the territory. Direct elections to the legislative assemblies, which is one of the paramount features of representative democracy in India, cannot be put on hold until statehood is restored. We direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30 September 2024. Restoration of statehood shall take place at the earliest and as soon as possible.